ladies and lords, in my respectful submission, the answer to this appeal is much narrower than my learned friend intends. This is not a case about jurisdiction in my submission. This is a narrow and fact-sensitive case about whether the appellant can deny a matter on which there was previously agreement. And they seek to deny it, not for some jurisdictional reason, where someone's acted in excess of jurisdiction, but they seek to deny it so as to avoid a statutory consequence. Ultimately, on the appeal, my case is the answer is in benedictus. And that's where I'll end up in my submissions. But there's three parts I'd like to address you on. On the appeal, before I turn to the respondent's notice. The first is, I'd like to briefly look at the statutory scheme, because we haven't done that yet. And I want to make some broader points about how the scheme works, what the purpose of the claim notice is, because knowing who the landlord under section 79(6) is important for feeding into who's protected under section 88. Secondly, I want to spend rather more time than my learned friend did, actually looking at the facts, the claim notice, the application form, the pleadings, what's said at each stage, because that will feed into the benedictus analysis, which is my third point. And I'll be frank about it now. My case is benedictus. If you're not with me on that, I'm going to lose on the appeal. And then I'll come to the respondent's notice. So can we start with the statutory scheme? And it's behind tab 1 of the authorities bundle. We won't look at qualifying buildings, suffice to say that some buildings qualify, some don't. We won't even look at how you set up RTM companies, because that's regulated as well. We'll go straight, if we can, to section 79 and the claim notice, which is on page 13. Now, there are two provisions in section 79 to draw attention to. This is how the claim starts, of course, your claim notice. You serve it as the RTM company, you say, these are the premises I want to take over. You have to identify the premises, you have to identify the date you're going to take over. And you have to give the claim notice to the 79(6) people, which is the landlord under a lease of the whole or part, and it can be any landlord. You can have intermediate landlords being served as well. So it's not merely the immediate landlord of the occupational leasehold tenants. A party to such a lease otherwise than as landlord or tenant, that's catching, for example, you used to in very old leases have maintenance trustees who do all the repair works. It catches in more modern leases, these tripartite leasehold controlled management companies. And then the third category, a manager appointed under Part 2 of the 87 Act. That's a provision that rarely makes its way to this tribunal. Essentially, it's a fault-based power, where the landlord has been misusing his power in some way, and the first-tier tribunal has power to oust him, leaves his title in place, but puts somebody else in place to manage the property. It has its genesis in the old High Court receiver model, and in the 87 Act it was created as a bespoke power for the FTT. The common thing about all of the people in section 79(6) is they are the people who are actually doing the day-to-day management. Those are the people who, under the terms of the lease or the management order, if it's an 87 Act manager, they are the ones who are arranging the insurance, the cleaning, the repairs, etc. Because that's what they're going to lose when the RTM claim goes through. All of those functions will become the RTM company's functions in due course. And we see that if you jump to page 36 of the authorities bundle. This is what the RTM company is going to get. 96.2 is the critical bit. Management functions of a person of a landlord under a lease under the whole or part are instead functions of the RTM company. 87 Act managers' appointments end when there's an RTM company, so you go back to what the lease said. And then the only exceptions are in section 97. They don't get forfeiture and things like that because they don't own a reversionary interest. So that's what the RTM is doing. It's transferring the day-to-day control of the building from the freeholder or some other person who's responsible to it, to this RTM company. Now, my Lady Justice Falk postulated a question to my learned friend about the position in respect of, say, a tenant who wanted to object to an RTM claim. That I never want to say, I don't want to say never, but it's quite unlikely you see a tenant objecting to an RTM claim. And that's because if you look at section 79(8) on page 13 of the authorities bundle, they only have a right to a copy of the claim notice.
Yes,
and if you jump,
they've been involved. They should also have been involved at an earlier stage.
so yes, so if you're a tenant in a block to which this act applies, if you are not a founding member of the RTM company, you are entitled to receive a notice inviting participation, giving you the right to join at any stage. This
join
is
the company.
Exactly, join the company. Yes. So you either if you're in a founding member, you don't need to be given that right. But if you're not a founding member, you get the right to join. So if you want nothing to do with it, just don't join the company. But you don't get a right to object because you only get a counter note. You only get a copy of the claim notice. And the people who can give a counter notice under section 84, which is page 18, I think, of the authorities, page 19 of the authorities. The people who can give a counter notice in 84.1 are the 79.6 people, not the other categories of people. So yes, of course, the tribunal has relevant procedural rules saying you could join interested parties. There's always, where there's a will, there's a way. But they're not the focus of this. The focus of this is the RTM company with its requisite majority of leaseholders. And we don't need to look at the mechanisms. Depending on how big the building is how big the majority needs to be. It's them interacting with the three categories of people who are currently doing all the critical things, ranging from placing the insurance to fixing the roof to cutting the grass.
Yeah. I mean, that category of people in subsection 6
yes,
obviously may include, and I think the Supreme Court commented on this in their recent decision, it may include people who don't actually have any involvement in cutting grass or whatever. But your point is that somewhere in that mix,
exactly,
it's going to be someone who does.
So in A1 properties, another defeat of mine, I'm happy to add them to the list. What had happened previously, there's been lots and lots of litigation, including getting up to this court's level, in a case called Elim Court, where landlords seek to take technical points to defeat RTM claims, and they say, well, you didn't serve this notice on that tenant, or you didn't serve the claim notice on this person who holds an intermediate lease of a storeroom, let's say, trying to invalidate it. And what this court said in Elim Court is that when assessing the consequences of such a failure, you ask yourself, what management functions did that landlord who wasn't served lose? Because if it's someone with an intermediate lease with no management functions, who cares? Because effectively Lord Justice Lewison's position in Elim Court. In A1, the Supreme Court say, no, that isn't right. That can't be the correct analysis. We'll look at it in a minute. They say it's a more broader point. Where someone fails to comply with a statutory scheme, and the statute does not tell you what the answer is, you have to step back and ask yourself, what was the purpose of that provision in the wider scheme of the Act? And what unfairness results from holding validity or invalidity? In A1, you've got someone who wasn't served. It was an intermediate landlord with no management functions. Not served. Their objection fails, not because of arguments about what they do under leases, but because they'd got wind of the claim anyway, joined the FTT proceedings, and advanced every substantive argument they could, so they were in no different position substantively than if they'd got a claim notice. So that's the A1 case there. It's not about the question we're grappling with. It's about, A1 is about what happens when you deviate from the Act. But they don't dissent from, and I'll take you to, we may look at it now. In A1, the Supreme Court agree, in my submission, with what I just put to you, that the critical focus of the RTM legislation is that practical question. We're taking the management off A and giving it to the RTM company. So if we look at A1 behind tab 10 of the authorities bundle. It's paragraph 66 and 67, I think. Yeah, so in 66 at 135, they review what this court has held in Elim Court. And the last sentence on 135. This court had decided the main purpose was to decide to show the right to manage. Person with substantive rights should be joined, but the purpose wasn't defeated if you served someone who was only an intermediate landlord with no management powers. And at 67, they say, well, that's not quite right. Where the effect of the, and this is the passage I'd rely upon, where the right to manage is transferred to an RTM company, the effect is that an existing sophisticated contractual regime with multiple aspects and ramifications is subject to significant disruption, hence the complexity and comprehensive statutory scheme outlined above. The ordinary expectation that persons whose property or contract rights are to be taken away or subject to quantification should have a fair opportunity and course of proceedings to be followed before that occurs. Contrary to the view taken in Elam Court, we don't consider that it's sufficient to say that the right to participate may be ignored if they are an intermediate landlord with no powers of management. So the Supreme Court accepts the broad policy point I just put to you. What this Act is doing is striking that balance between moving the existing statute, existing duties to repair, etc., from a Section 79(6) person into the RTM company. But the rest of A1 is about a much more interesting question of broader application. What do you do with legislation where it says you must do X, but doesn't tell you what the consequences are if you don't do X?
That's a general question which arises with all sorts of... Parliament very frequently says what you have to do, very seldom tells you what happens if you don't.
I find I'm back to where I was in January having the same discussion. Yes, it's a modern drafting technique, isn't it? It's Parliament says X and then doesn't bother to tell us what the outcome is. And what their lordships decide in A1 is to go back to an earlier case of theirs called Soneggi.
Soneggi, yes.
And essentially, if I had to summarise A1 in 2 sentences, it would be, go back to what we said in Soneggi, ignore the various glosses that have been put on that over time. That's the A1 point, and that's the point that went up for their lordship's consideration, because, as you say, a vast range of statutes are affected by that principle.
And the answer is, it all depends on the construction of the Act in question.
Yes.
And what the purpose is of Parliament telling you to do something, and then you have to interpolate what the consequences are of not doing it.
The slight gloss from A1 is they say it's acceptable to test the consequences in the sense of would greater unfairness flow from holding validity or invalidity. So it's not a pure black letter, read the Act and try and work it out. You are allowed to extrapolate and work through scenarios. But that's not our case here. The reason I just wanted to look at Section 79(6) and then A1 is to get the claim notice in its proper purpose. It's trying to make sure that the people that do the actual management of the building know that they are about to be ousted, or that someone is attempting to oust them. And the reason for that is obvious. They're going to have to cancel the insurance. They're going to have to get different cleaners. They're going to have to give notice to various contractors. There'll need to be discussions about if there are contractors the RTM company really likes, can it novate itself into their contracts? You can see why you need proper notice of the fact that someone is trying to remove your duty to manage this building. And that's what Section 79(6) is doing. I jumped out of the Act, sorry. I wanted to go back to the counter notice as well. Page 19 behind tab 1. I made the point that 84.1 that it's only the Section 79(6) people who can give the counter notices. And that was to pick up on my lady's point. Tenants won't get to give a counter notice. So whilst you could have a scenario where a tenant is a party in the FTT, they never have the right to give a counter notice. I was just looking at those counter notices in 84.2 because they have to do one of 2 things. You either have to admit the claim or you have to deny it.
So when it says in 84.1 a person who is given a claim notice, you say that's not 79.8 under which a qualifying tenant is given a copy of a claim notice.
No, because the next bit of the sentence makes it clear. Where a person who is given a claim notice by an RTM company under Section 79(6).
I see.
So that solves it. So
yes,
so
it's only the 79(6) recipients.
Exactly. Because it's only them who are going to find themselves in a worse position because they're the ones who are losing their current obligations. So if you're the freeholder, you're a landlord under a lease, you're given a claim notice. Let's assume a nice simple lease, there's no third parties, no managers involved at all. inevitably you will have been arranging the cleaning of the common parts, you will have been insuring the building, you will have been repairing the roof, etc. You need to know that potentially in 3 months' time, that's the shortest window you could do this in, that potentially you have to stop. That's why it goes to the section 79.6 people, because it all ties into management. That's what this whole scheme is about. I just wanted to pick up on the 84.2 and point that the counter notice can say one of two things. You can admit or deny. Now, I appreciate cases that get to the tribunal or to this court have only ever denied. That's the whole base, because without a denial, you can't have a litigation about it. But you could admit it. And I just flagged that up because, again, a point my lady put to my learned friend in argument. How would Judge Cooke's stop all work if there were never proceedings, if there were only a claim notice? Well, that might be one scenario. You might have a claim notice that you admit. I want to be very careful about where I go with defending Judge Cooke's decision. She may have got the date on which the estoppel arose wrong. I can see the questions that were put to my own friend. I can see the force of it. But we're appealing her order. And her order is in the main appeal bundle at page 125. The sum that she assesses as being due under section 88 is that £11,747.22 figure. That's the section 88.1 costs and the section 88.3 costs. So she may.
Sorry, which page are we on?
So 125 of the core bundle behind tab 10.
Yeah, but if that's so, she's actually given no reasons why she's included the first set of costs. Actually, I appreciate your point that the costs applied for and that she carefully looked at cover both categories.
Yeah. No, I'd accept that. I can speculate. One reason may be, as you might imagine, the section 88.1 costs are normally pretty modest. It's just investigated.
Wait, paragraph 5 tells us about
some
that.
figures.
Yeah. Yes, solicitors spent £1,700 on the section 88.1 costs.
Well, we don't know whether that's the full amount of costs of the full estate, because those two figures don't add up to the total.
No, the rest of it's almost certainly me, I suspect.
There's some managing agents fees as well.
There were some managing agencies claim. We can go through, we've got all the cost submissions in the bundle, so we can go through and work it out if we may. But my lady's point is right. I accept there isn't that degree of analysis. The point I simply wanted to make was, I'm going to defend the point of principle she came to. So if I can just take you to her decision. A critical bit of her decision, in my respectful submission, is her paragraph 50 on page 96. That's ultimately where she gets to. The unfairness of the RTM company's attempt to pursue the appellant in the FTT on the basis that it's the landlord, then to deny liability for costs and basis not the landlord is obvious, reflected in the legal position that the RTM company is stopped from denying the appellant is the landlord for the purposes of covering costs under section 88. No need, not proportionate, to decide the other two grounds, and those other two grounds my respondent's notice point. The long and the short of it is, that's right, paragraph 50. And that's right because it's completely consistent with Benedictus.
Okay. Before you made this point, you were making a point about counter notices potentially admitting.
Yes.
Which I suppose I myself like to understand a bit better, because as you've said, there could be lots of different people under 79.6, therefore lots of different people who could serve the counter notices, either admitting or challenging the claim. The fact that someone admits it doesn't give you a sort of green light through the rest of the process because others might object.
No, and section 84 tells you why that is. So it's section 84(3) on page 19. Where the RTM company has been given one or more counter notices containing a statement as is mentioned in subsection 2b, i.e. a denial, then it may apply to the appropriate tribunal for determination. If it doesn't apply within the time limit, it's deemed withdrawn and the whole thing falls away.
As I understand the way the scheme works is if you get nothing back, or if all you get back are admissions, then the thing sails through.
Then you get it on the date. Then you get the RTM on the date in your claim notice. Yes.
Which has to be a minimum of 3 months. But if you get any denial from one of the people in the relevant category, the only way through is then to apply to the tribunal.
Unless someone who gave you a negative counter notice withdraws it later.
Right.
But yes,
Right.
yes.
So I was just coming back to your point about the significance of admission. It's not significant unless you're the only person giving any notice or entitled to give any notice. It may not be that significant.
It may or may not be, no. It all depends on what the relevant interests are at this building.
Yeah.
I know.
Is the reality though that from what you've been telling us about the shadow boxing that goes on in this area, that it's not that often that there's just a straightforward admission leading to a seamless transition to the management company?
So I wouldn't want to say that because inevitably, if there's no denial, frankly, it never gets to my desk, so I'm never going to see it. So I don't know what I don't know, if I can put it that way. But it's not at all uncommon to find different tiers of landlord taking different lines. So I have one coming up in the Upper Tribunal in January, where we are an intermediate leaseholder of it's the old Central London County Court, actually. The Crown Estate are the freeholders. They served a positive counter notice. They don't mind at all. We think it would be terrible for our interests, so we serve the negative counter notice. And it's going to be an argument about, does the building qualify, where are the lines in it, etc., etc. Is it a physically separate building? So you can get different stages.
It's a combination.
But I suspect largely driven by their respective interests. If you are the freehold reversioner, you've granted a 999-year lease to an intermediate landlord. The reality, this may not be the strict law, but the reality is you're probably not going to care very much because it's a 999-year lease. There's no rent under it if it's a peppercorn. You're just holding it for that eventual reversionary value. If, by contrast, you're the freeholder, there's 21 years left on an intermediate lease, you might have a lot more interest because you can suddenly see, well, this might come back to me within a reasonable period of time. So it all depends, is the answer.
Can I go back to what happens if you don't get any counter notices at all?
Yeah.
You don't apply to a tribunal, it just happens under
No,
the
that is the massive difference between this legislation and the enfranchisement legislation it's modelled on. So under the enfranchisement legislation, you serve your claim notice, you're trying to buy the freehold together. You still have to go to the county court to get your order confirming that the building applies. The textbooks give the example, it's why you couldn't enfranchise London Zoo, even if they ignored you, because the judge would never make that order. But no, under this legislation, if no one serves a counter notice, there's deemed admission for everyone. It is yes, it's section 90 on page 28. This section makes provision about the date on which the RTM company acquires the RTM. Subsection 2, where there's no dispute, the acquisition date is the date in the claim notice. And then sub 3, there's no dispute if no counter notice is given under section 84. So if all of the freeholder, or all of the people in section 79.6, sorry, if all of the people in section 79.6 just sit on their hands, there's deemed to be no, there is no opposition, and you get the RTM on the date in your claim notice. If they all serve positive counter notices, you get it on the date in your claim notice. If any one of them serves a negative counter notice, you have to go to the FTT within a period the Act specifies, If you don't go within that period of time, you're deemed withdrawn and your claim falls away. And if you do go to the FTT, then the litigation process takes its course, whether that's success, failure, withdrawal, whatever it's going to be.
Is the deemed withdrawal, where's that?
Hang on.
Just a couple back.
Yeah.
Just been looking at that. That's 47.
Thank you.
Thank you.
Yes, there we are. If you're given a counter notice and it contains a statement as mentioned in 2B, i.e. denial, and you don't apply under subsection 3 within the period of subsection 4, then the claim notice is deemed to be withdrawn. And if your claim notice is deemed to be withdrawn, you can't subsequently go on to make a claim.
And does that generate a liability for costs under 88.1?
It does because of sections 88 with section 89. So if you go to 26 and 27,
Yep.
Yes, I see. Deemed to be withdrawn.
yes. So 89, and this is one of the cases that's mentioned in the skeletons, it's an Upper Tribunal case called Plintal. That's all about deemed withdrawal cases. This is a section 88 case, of course. So section 89.1, where you've given a claim notice and it's at any time withdrawn or deemed to be withdrawn, then 89.2, the liability of the RTM company under section 88 is for costs down to the date of the withdrawal, or the deemed withdrawal, as the case may be. So 89 works with 88 for that scenario where the act has kicked in and it's been withdrawn, or it's expressly withdrawn.
You said that if you don't get any answer, or if all the answers are positive,
Yep.
then you just get it without going to a tribunal. What you get is a right to manage. There's nothing vested in you. You don't get any property interest.
No.
But you do get contractual rights against the occupying tenants, and management functions and all those things.
You do. So you get the section 96 rights. So all the management functions of a person who's a landlord under a lease become the functions of the RTM company. Management
So that's a sort of statutory novation, is it?
The textbooks have grappled with what it is, and I'm not sure anybody's ever tried to look at it. Can I just answer as to what management functions are? Then there's one other thing they get as well, and I'll try and pick that up. The management functions are defined in section 96.5. They are functions with respect to services, repairs, maintenance, improvements, insurance, and management. And it won't have escaped your attention, that's the first part of the statutory definition of a service charge in the Landlord and Tenant Act 1985. The second part is, and that it varies according to the relevant costs, i.e. the landlord's costs. So the simplest way to think about it is that what they get is all the service chargeable functions.
Functions are slightly odd, but does that give you the right to sue for service charges? Is that a function?
The state of the current authorities is yes, and the view that's taken is that the section 97.4 is the answer. As far as any function of a tenant under a lease, then that becomes exercisable in relation to the RTM company. So the function of paying the service charge becomes payable to the RTM company.
Function still seems a very odd word to pick up obligations, but there we are. I mean, if that's how it works. That's how it works.
Should my lord be bored of an afternoon, he can ask Justice Lewison what he thinks of this act, because I think he has very similar views about the quality of the drafting from last time I was in front of him on this. The other thing the RTM company gets for completeness, I don't think we put it in the bundle, but it's Schedule 7, I think it is. A whole range of statutory functions change as well, for obvious reasons. So just as landlords have to keep their service charges in a trust account, they can't run off with them, so do RTM companies. Just as landlords have certain repairing duties imposed by statutes, those go to RTM companies as well. So there's quite a lot that transfers over. And that background informs what we're grappling with here. Because one of the things that my own friend took you to, and I'll pick this up in a moment, he took you to the evidence that the members of his clients had, which is our service charge demands. We're doing this. We've been doing all the cleaning, the repairing at this building. We've been charging them for it. the suggestion that we're not a landlord, I'll be quite frank about it, it emerges for the first time in the costs application because it's an attempt to avoid a statutory consequence. It's not because it's a serious point. It's because it's an attempt to avoid paying our Section 88 costs, not because there's any real doubt. Now, if he's right about jurisdiction, he's right about jurisdiction. But let's not pretend this is some difficult case where there's been vast uncertainty. It's an argument to avoid a statutory consequence. And that statutory consequence is the Section 88 costs. So if we just jump to that. The three categories of person who get their Section 88 costs at page 26, those are the three categories who get the claim form. It's because it's recognising that they're the ones who've got to do work when this is served upon them. They've got to satisfy themselves the building qualifies, they've got to satisfy themselves the claim is properly made, and even if they think this is a perfectly sound claim and there's no defence to it, they've still got all the work that comes with the handover. So Section 88(1...
Do they get paid for handing over? They don't, do they?
Well,
They get paid for the costs of looking at the application.
they get their costs in consequence of a claim notice. So there is an open debate about how far in consequence of a claim notice goes. Where does investigating the claim stop and handing over begin? And ultimately, if you can't agree these things, this is what the FTT does, not quite day in, day out, but you could wander down to Alfred Place and watch at least one of these a week if you wanted to. Under Section 88(3), it just works out. Well, is it a cost that falls under the 88(4)? Is it a cost that was properly due? Is this really a cost in consequence of a claim notice, or is this actually a backdoor attempt to get your management fees? So that's how the scheme works. The 88(1) costs you get come what may, because they're recognising that you were given a statutory notice and you have to do something in response, admit or deny. You could decide to stay silent, but that's incredibly unhelpful for everyone. And then 88(3) is recognising that where you are an 88(1) person and you dismissed the application, you defeated the application, then you have a right to your costs as well. It's not so much conceptualised in my submission as one-way cost shifting. It's preventing this whole scheme being expropriatory. You've been served with a notice, someone's trying to take your rights off you. You say, well, I don't think you should take my rights off me, I think your claim is flawed. You succeed on that, why should you be out of pocket?
Well, it is ultimately what you describe it as not being, because a successful application takes away the right of management.
Yes,
which it sounds as though a lot of landlords would prefer was not taken away, otherwise they wouldn't be disputing it.
Landlords generally do oppose it for a variety of reasons, good and bad.
Presumably money figures somewhere in that.
So there are two, to be perfectly frank.
Yeah.
One is many landlords can find ways of making money with this arrangement. You have a management company you control, managing agents who do it all. The other, which again, Lord Justice Lewis intends to scoff at me when I make this point, is that there's actually very different degrees of interest. Freeholders, of course, are generally going to be holding the building for quite long periods of time, and they don't really mind building up reserve funds to pay for the repair in 20 years' time. Leaseholders don't tend to hold the flat for as long. They're generally thinking about a more short-term financial expenditure. That's the inevitable tension you get in all along leasehold litigation. The freeholder's thinking, well, I've got obligations that are going to run for another 500 years. The leaseholder is thinking, I'm going to sell this flat in 5 years. Why do I want to keep contributing into that reserve fund? So yes, so they do want to keep it for a variety of reasons. Some mercantile, some stock management related. But the reasons don't matter. Point is that they're the category of person in Section 88. The Section 88 categories marry Section 79(6). And what this whole scheme is driving at is making sure that the person who's about to lose their rights knows what's going on. That's why you have that category in Section 79(6). defined by reference to the categories of people who actually do work at buildings. It's why leaseholders are in a different category. That's the only point I wanted to make on the statutory scheme. Can I then just spend rather more time than my learned friend did on the facts and how we got here? And can we start with the claim notice, which is in the supplemental bundle at page 237. So this is how we start the ball rolling. This is what's going to give rise to the section 88(1) liability. So page 237 is the covering letter. You'll see it's addressed to my client. Claim notice pursuant to the 2002 Act. Please find attached a claim notice pursuant to the Act. If you are a leaseholder, it's sent for information and to comply with the Act. That's section 79(8). We just saw that's why they get it for a copy. If you are either of the freeholder, head lessor, or another party required to be served with a claim notice under the lease. And this next bit is important. It doesn't say if you are one of these things, but we think you might be, we might not be, we're doing this to cover our back, this is equivocal, we don't want to be hit with arguments later on. My learned friend would draw attention to the fact that he said this was equivocal. It isn't. If you are one of those things, then we testify by way of this signed witness statement that the claim notice type is automatically printed, inserted into an envelope, etc., etc. Someone's written this trying to rely upon the Interpretation Act. There's no equivocation about what Assethold is under this letter. Then over the page you get the actual notice. There's no equivocation in the notice either. Addressed to Assethold Limited, and then Millcastle Properties Limited, and then it just follows the statutory form.
Why is it addressed to Millcastle?
They were the registered freehold owners still. So what had happened in October 2019, we'll look at this in the FTC decision in a moment, we purchased the freehold reversion and the head lease of this building for reasons that actually haven't been determined yet. That wasn't registered until much, much later. So on the date of this notice, if you'd gone to the land registry, you'd have found Millcastle Properties as the registered owner. But in fact, we bought it some 2 years ago.
And Millcastle Properties was the registered owner of the freehold.
Yes.
A different Millcastle entity.
Held the head lease, yeah.
And it's quite significant. It was a 999
Yeah.
year head lease, so it's in the category you mentioned earlier.
Yeah. It's where the money was, and frankly, this building. Yeah.
Yes. Which is quite interesting because the focus of the debate seems to be more on freehold, but we shouldn't.
Well, we acquire both. As you'll see, we'll look at the FTC in a minute. We actually acquire both the freehold interest and the head leasehold interest. The difficulty and the reason why this whole argument opens up is because, as it's important to make clear this, for reasons no one's determined, it isn't registered promptly. The FTT speculates as to why that might not be, and my learned friend speculates. But no one's actually made a finding as to why it wasn't registered. But this notice is following the statutory scheme. It's not equivocal in any way, shape or form. So paragraph 1 complies with the statutory requirement, albeit we argued about this later on in hearings. But what it does, it says, we're the RTM company, we want to acquire these premises. Paragraph 2 explains why they say the Act applies. Paragraphs 3 and 4 are the prescribed information you have to give to make these things valid. It tells you who the leaseholders are, how long their leases are, etc. Paragraph 5, if you are the landlord or a party to a lease or an 87 Act manager, then you may respond by giving a counter notice. If you give the counter notice, you've got to give it no later than the 15th of the 7th, 21. They give the date they want to acquire the management. I don't see 7, 8 or 9 take us any further anyway. Then we have the schedules, which is the details of the members of the company. And then you have the prescribed notes on 242. The prescribed notes tell you at 1, you have to give this notice to everyone who, at the date it's given, is a landlord under a lease, party to a lease other than landlord or tenant, or a manager under the Act. You don't need to give it to someone who can't be found. If there's a missing party, you apply to the Tribunal for directions, etc., etc., etc. So there's no equivocation here at all. It's served upon us, and the only thing it can be served on us as landlord. No one's ever suggested we're any of the other two categories, some other party to a lease, and we're plainly not a 1987 Act manager.
But it does say if you are the landlord, party, manager. This looks like another standard form.
Which page are you looking at, my lord?
Sorry, on page 239, paragraph 5.
239.
It doesn't say you, Assethold, are the landlord and you have the right to serve a counter notice. It's just, in general terms, if you, the recipient, are any of these, then you have a right to give a counter notice.
But that's because this is the prescribed form, and that's because this form has to go to both the section 79.6 people, and a copy of it has to go to the section 79.8 people as well, i.e. the tenants. So what paragraph 5 is doing is telling the tenants who are also getting this notice that they don't have that right, because it's only the section 79.6 people who are allowed to give a counter notice. So it's not saying, I don't know if you're the landlord or not. The target for that paragraph is the X number of leaseholders in the building who've got this, who need to be told they don't have a right to do things the other three categories of people do.
So you'd say that equally applies to the letter 237 if you're either.
Well, I'm not sure it takes us any further, because it's the what is it doing? If you are either of these people, then all it's saying is we're going to take this as evidence of good service.
Okay.
If you were genuinely trying to say, I'm serving this on you out of an abundance of caution, you wouldn't do it this way. Then the counter notice comes back, which is page 243 of that bundle. And that, as we canvassed before the short adjournment, effectively just takes every point going.
That's every possible objection, isn't it?
I wouldn't say every possible objection, but certainly enough. So the key ones, so one, for example, one ends up actually being quite important, because that's the substantive one we end up arguing about in the FTT. We would have ended up arguing about in the FTT. One is an argument about what they'd claimed, is that actually they only appear to have claimed 16 flats and there are 17 flats in the building. So one's actually quite an important one. But the rest of them, frankly, are the standard procedural objections. You can't prove you sent this to every single leaseholder as required. You can't prove you sent this to every landlord. Now, that may have been more important, given the intermediate landlord point in this case, and they're not one of the named recipients. But this model of notice is very common. As night follows day, minor variants of this are served in almost all the cases.
It's not a very informative document.
No, I agree.
I mean, the Act is plainly envisages that the landlord will set out what his objection is, rather than just recite all. It's one of the following, all possible objections.
So where the law has got to on that, only at Upper Tribunal level, is they would agree with you that it's not particularly helpful. They would point out that it doesn't actually require in the Act any particular degree of specificity. It just says you have to identify by virtue of a provision of the Act why you don't qualify. And then the reality is we all get our information at pleading stage.
So you put in 7 bad reasons and 1 arguably good reason, and that's compliance with the statute, which tells you have to say what your reason is.
Seems a fair summary.
As I'm sure my lord will appreciate, and that sums up landlord and tenant law for the last half century or more.
Yeah.
Anyway, that's the counter notice. You then get the application and the claim, the application and the pleadings. Staying in the supplemental bundle, it's page 161. We've looked at this briefly.
But just before we leave the council,
My lady,
says, I take it you agree that the people able to serve, well, you've made this point, the people able to serve counter notices are those listed in, among other things, 79 subsection 6
Yes.
and 84, as in landlord, party to the lease, etc.
The 3 categories of person who can serve a counter notice are the three categories of person who are entitled to receive a claim notice. So it's quite plain on the face of the Act, it seems to me.
Yeah.
Section 79.4 and Section 84.1, they go together hand in glove.
Does that not therefore amount to an assertion by Assethold Limited that I am within Section 79.6?
Yes, very much so. It's serving a counter notice.
Yes.
Yes. If it's not within that category, what it's serving is a nullity. But the claim then starts with the application at page 161. We've looked briefly, so I just want to look at two parts of it. This is the FTT standard form, as you might imagine. We've looked at box 3 on page 163, address of landlord if not given. And the lady picked up, it's actually name and address. Name, Assethold Limited address, then the address for correspondence, etc. And then just over the page, at page 167, this is also important because this tells the tribunal what you're asking it to do. So they've ticked box 1. It's an application under section 84.3, i.e. an application for a determination that on the relevant date, which is the date of the claim form, the claim notice, sorry, the RTM company was entitled to acquire the right to manage. And then they have to provide the tribunal with the claim notice and the counter notice. We haven't included those in the bundle because you've got them at various other places. So that's what they're asking the tribunal to do. Make that determination that they were entitled to acquire the right to manage. We then come to the pleadings, and these start at page 170. And we start with the RTM company's pleading. They explain at 170 that a number of them got together and decided to commence these proceedings. They explain at 171 under the heading Section 78 Notice Inviting Participation how they've done the prerequisites, effectively getting their qualifying majority. And then 172, Section 79 Notice of Claim. The claim notice was served by first class post on the freeholder, Assethold Limited, 5 North End Road, Golders Green, London, UK, etc. And the freeholder's agent, Eagle Estates Limited. Identical claim served by registered post on the freeholder, Assethold 5. Copies shown in the bundle. Counter notice received, copy included here. We then serve our pleading in response, which is at page 173. And at paragraph 2, we explain the position. So no one can be in any doubt about what the position is. We purchased the freehold, described as 159 to 167, on the 10th of October 2019. Registration is pending. Millcastle Properties remains a registered freeholder. Copy of the plan, title plan and TR1, so the document proving our purchase effectively, are enclosed at Exhibit 1. Then we describe the building, and then we start to go into the arguments about why the building doesn't qualify. Nothing turns on that for these purposes. The preliminary issue was effectively the substantive point. Does the building qualify physically or not? And then you've got arguments about the scope, forms of notice, etc. And then the reply from the RTM company is at page 177.
Do you explain what happened to the long lease?
We don't, I don't think. It wouldn't matter for the purposes of the appeal because I've only got to be a landlord under a lease. So if I'm the freeholder, that's enough. Because I'd either be a landlord under the intermediate lease, or if the intermediate lease is merged into the title, which might have happened if we own both, then I'd be the direct landlord of all the occupational tenants.
Yes, I see. You don't take the point, which you might have been able to take, I suppose, that under 79.6, the Millcastle PFW Limited was a landlord and wasn't served.
We did at page 174.
Oh, right, okay.
sorry, I skipped over this because it all gets withdrawn. The actual ins and outs of the argument don't take us very far, but we did identify that at 174, paragraph 19. Sorry, I should have gone a bit more slowly. The point I'm seeking to get from all this, as you can see, is that there was effectively consensus about our status. And that's why I now need to take you to 180, the respondent's reply. So they've seen our paragraph 2 now, they've seen us explain everything.
So where are you going next?
Page 177, sorry, in the supplemental
Thank
one
you.
still. So they put a picture of the block of flats on the front. They're running through responses to why people were served, etc. And then at 180, top sentence, claim notices were sent to both the freeholder and head lessor. So yeah, I think I should have picked up my Lord's point. This is where they pick up the point my Lord just put to me. Claim notice to the freeholder and the head lessor, Assethold and Millcastle on the 8th of June, and copies are attached. So they know the position, we've explained it in paragraph 2. Nowhere do they doubt we're the freeholder. Nowhere do they doubt that we are someone who should have been served with this notice. Now, for completeness, we served a further reply to their reply at page 181. That document has nothing to say about titles and statuses. It's all about the substantive arguments. But just for completeness, you have got a reply to the reply at 181. You then at 189 have how their claim was concluded. This is the day, I think, a day or 2 days before the hearing was due to come on. They applied to withdraw their application. The tribunal judge is satisfied they've complied with the relevant rules around applying to withdraw. And upon the applicant, which is them at the request of the respondent, which is us, confirming that they're content for the withdrawal to be treated as a dismissal, and that's important because I want my 88.3 costs, not merely my withdrawal cost under section 89. I hereby consent to the withdrawal and also dismiss the application. We then apply for the quantification of our costs under section 88. You find our application at page 190. We tick box 5 on page 192. We're happy for this to be done on paper. That, as you might imagine, is quite common. It's effectively a summary assessment process. And on page 195, you see we've ticked box 3. We're asking for our costs under section 88.4. The RTM company files a statement of case, which is at page 200. And at page 201 is where we get the first argument that we are not a landlord. So you see paragraph 5 on 201, filed by Assethold under section 88.4. Assethold's application states it as a landlord. We presume it has an interest, and it claims an interest under section 88.1a, but it's not registered. They draw attention to what we said in our pleading. It still hasn't been registered, they're paragraph 7. Separately, our acquisition of the head lease hasn't been registered, although they attached the deed dealing with it. Paragraph 8, they don't know why it hasn't been registered. They suspect that our TR1 is defective. That may or may not be right. We still bought it. That's the point. We still purchased this land, even if we have messed up the land registry form. They say, paragraph 10, can't have an interest in land without a deed. The TR1s are not duly executed. And then paragraph 13, second half of paragraph 13, Prince of Wales Road RTM invites the tribunal to determine that Assethold does not have standing under section 88 and it's not a landlord. If the tribunal so determines, the application falls to be dismissed. And then they have individual points about the challenges to individual sums that were claimed. Those who instruct me respond at page 214. They reverse the order and spend more time talking about why their costs are reasonable in amount. It's page 218 where they deal with the landlord point. Paragraph 13. As noted by the respondent, the applicant purchased the freehold on the 10th of October 2019. We stated that in our previous statement of case. We've given you the TR1. The application is still pending. It was clear the respondent was aware of the capacity of the applicant, having given us a claim notice. And then C, the respondent issued proceedings against the applicant under section 84.3, confirmed the capacity as freeholder within the application, and confirmed it with a landlord in its statement of case. As such, the applicant will contend the respondent will now be stopped from denying liability for costs incurred in response to the claim notice and the costs of the proceedings in due course on such grounds. So we say estoppel, both section 88.1 and section 88.4. The reference to claim notice is section 88.1 costs, proceedings is section 88.3 costs.
Sorry, 88.1
and 3. So 88.1 is the cost and consequence of the claim notice. 88.3, not 4, I got it wrong. 88.3 is the costs costs of the tribunal proceedings where the tribunal dismisses the claim.
Strictly, that I think I read that as an aspect of the 88.1, just as a matter of how the statute works.
I think that's probably right. It's where does it stop effectively?
Yes.
If X, then you get this bit as well. But if not X, then you stop here. I think that's probably right conceptually. I'm not sure anything turns on it for the purpose of this appeal. Because for the purpose of this appeal, what I want to take you through all of that was to make good my point. This turns up for the first time at the very last moment as an attempt to avoid a statutory consequence. And that's going to be important when we come to Benedictus.
Just pausing here then as to what the estoppel is that's asserted, because you touched on this as well. It is, the focus is on the issue of proceedings.
So what's relied upon it seems to me is B and C. It's the giving of the claim notice and then it's the further. So they're relying additionally upon the claim notice. So further, it's the issuing of the proceedings and then the positive aversions in the pleadings. But the point that's being made, albeit not in so many words, but to flag up with where Lord Justice Bingham goes in due course, you can't approbate and reprobate. You can't on the one hand issue a claim against us saying you are our landlord and then deny that for the purpose of avoiding a consequence. So I accept in part it's the issuing of proceedings. I'd say actually in context it's a bit more than that, because the reference is made to the claim notice and the reference is made to the actual state of the pleadings. So then can we go to the FTT's decision, which is in the main appeal bundle at page 132. In accordance with our request, it's all dealt with on the papers. I just need to start at 133. Some of these paragraphs become more relevant later on to the respondent's notice point. Paragraph 2, the judge is directing himself by reference to the history. I said the only way you can read paragraph 2 is he accepts that we did indeed purchase this property, as we've been saying that we have all the way along. The applicant, Assethold, purchased the freehold of the property on the 10th of October 2019. It also purchased the head lease. Neither purchase has been registered. Then at paragraph 11, is paragraph 11a, he clearly understands the argument that's being put to him. Assethold has no standing, that it's not registered, and neither transfer deed has been executed by them. He understands then the italicised passage over the page. what our response was, i.e. that we purchased it, application is still pending, they were aware of capacity, and then the issuing and the pleading point we just looked at. Paragraph 14, starting point where the tribunal has standing to consider the application, and really means whether Assethold has standing to bring the application. Turns on whether Assethold with the landlord under a lease for the purposes of section 79.6. And this last sentence is important. The purchase of the freehold and head lease completed on the 10th of October but are yet to be registered. So there's a finding that indeed we have purchased it. Paragraph 16, I'm not going to go into any great detail, is effectively his supposition about why it hasn't been registered yet. It does look like there might have been a problem with the TR1. Paragraph 17, over 3 years have passed since the purchase of the freehold and the head lease. We haven't explained the delay. Paragraph 18, transfer do not operate in law until they're registered by virtue of the Land Registration Act. That's true. Transfer as a disponee must be completed by registration. That's true. During the registration gap, Assethold has only equitable rights as against Millcastle. So there's a finding we must have equitable rights, i.e. that we do indeed have the rights of purchaser. And then his conclusion at 20, we weren't a landlord under a lease because we had no legal interests. Equitable interests aren't enough. Means the claim notice was not given under section 79.6.1, so we had no standing to serve a counter notice and no standing to claim costs under section 88. Now, the Upper Tribunal is right to reverse that, and I'll look at Judge Cooke's reasons in due course when I respond to what my learned friend said. But as I said at the first part of my opening, I say however you look at this, Judge Cooke's paragraph 50 on page 96 is the answer. The unfairness is obvious. And so she concludes there's an estoppel. She and I, in due course, will give you more details to make that good. But that's the nub of this. That's why I said this is so much narrower than my learned friend put it. You have to have a situation where a claim notice is served, application is issued, pleadings go in, including from us putting our cards on the table and explaining the position. No one denies anything in there, and the first time the point is taken is to avoid the statutory consequence. Benedictus is authority for the proposition that that simply does not work as a matter of principle, and we can look at the route by which you get there. So let's turn then to Benedictus, which is in tab 13 of the authority statement. If I can just summarise the facts and then I'll jump into the judgment in a moment. My learned friend started with these facts. Let's just take them more slowly. The tenants have sought a new lease under the Landlord and Tenant Act 54. And of course, one of the requirements of that is that you're in occupation. Having sought that new lease, the landlord did what all landlords do, which is ask for an interim rent, because it takes time for the new lease procedure to go forward. The tenants tried to resist paying that interim rent on the basis that they're not in occupation and therefore not entitled to a new lease, and therefore you can't have an interim rent off them. The interim rent hearing comes on, and the tenants advance that argument, and the judge says you can't do that. You can't put forward an application for a new lease which asserts as a necessary element of the claim, and indeed was actually averred, that you are in occupation, and then deny that fact to avoid the consequence of your application, i.e. the consequence is that you will pay an interim rent. And that's the fact pattern the Court of Appeal is grappling with. If you go to page 181, about a third up from the bottom of the page, Lord Justice Stocker sets out the arguments that were advanced because they are almost indistinguishable from my learned friend's arguments. The arguments put forward on behalf of the tenants on the issue of convention estoppel are: 1. The parties cannot, by agreement, waiver or estoppel, grant the court a jurisdiction which it does not in fact possess. 2. In any event, estoppel is based upon evidence, cannot be derived from pleadings, even if, contrary to the earlier pleading points, there are such pleadings. That, with the best will in the world, or he puts it in a slightly more complicated way, that's the gist of my learned friend's case. That's why he took you through all the cases about you can't expand jurisdiction by estoppel, and that's why he took you to his argument that you can't prove, I can't prove any detrimental reliance here. So let's look at how his lordship deals with that. Page 182 through to 183, the sideline passages. I don't want to go through all of them because I suspect the court can read them in due course and because the point I wanted right at the end. But what he's doing there is directing himself by reference to the key cases that say you can't use an estoppel to confer a jurisdiction that doesn't exist. The important bit is the end of 183. In my view, it's clear law that the parties cannot by any route enlarge the jurisdiction of the tribunal before whom a matter falls to be decided. I agree. I'm not remotely challenging that. There's authority, as long as your arm, full way up to the Supreme Court that stops me doing that. But that's not what's happening in this case, he says, and it's not what's happening in our case. The question arising on this appeal is whether or not the effect of the estoppel pleaded is to enlarge the jurisdiction of the court, or, and this is my case, whether it solely concerns an estoppel which precluded the tenant from denying an essential fact necessary to establish their right to a new lease, that at the time of the application, the premises were occupied by them for the purpose of their business. Going on down to the last sentence in that paragraph, in my view, the tenant's contention does not give rise to a question of jurisdiction, but arises as an issue relevant to their claim for a new tenancy. Well, that's us. They're saying that they satisfied section 79(6)(a) by serving us. That's the essential fact that they relied upon in their application to the FTT.
Is that really so? I mean, on the face of it, their ability to acquire the right to manage depends, as you say, on the property being the right sort of property, the RTM company being formed in the right manner, etc., etc. Yes, one of the things is you've got to serve the right people, but it isn't a requirement that you've only served those people. So put it another way, it's surely not, a claim notice is not invalid because you happen to serve it on someone else.
No, I'd agree with that.
Landlord. So what I'm trying to say is that the Assethold status as landlord or not, to what extent is that really in the same category as a tenant in occupation? It seems closer to, you know, are these tenants the right sort of tenants of holding long leaseholds and have they correctly formed the RTM company?
Well, suppose they'd never served Assethold. On the face of it, Assethold then has there is then an argument, it's the A1 Properties argument. What's the consequence of that? It might well have been the claim was dismissed. We'd have had to go through and consider purpose of section 79(6), what's Parliament's intention, what game out the consequences.
But it doesn't, if Assethold isn't a landlord, it doesn't make the process invalid.
I agree with that. But that's not what they were doing. So this is why I said at the beginning this is very narrow and on its facts, and it's why I took you to all of the material in some detail. This is in no way equivocal.
Well, okay, I'm probably not putting my point very well, but let's put it this way, if you could put it in terms of necessary elements of a cause of action, I know that's not quite this situation, but by way of analogy, in Benedictus, a necessary element of their ability to apply for a new lease is that they were in occupation. They could not even get the process going. They didn't have standing. This situation is somewhat different.
A necessary element of an application to the FTT under section 84.3 is that you've received a negative claim notice. That's what gives the tribunal jurisdiction.
Can we have another?
Yes, of course. If we go back to the authorities. Page 19. Uh, 84.3, where the RTM company is given one or more counter notice containing a statement as mentioned in subsection 2, the company may apply to the FTT for a determination it was on the relevant date entitled to acquire the right to manage. That's your only way into the FTT. It doesn't have a freestanding originating jurisdiction. Your only right to apply to it for the order that they asked for is that someone has given a section 70, a section 80, sorry, a section 80.
It's 84.1.
84.1, yes.
Yeah, it's that. I mean,
Yeah.
your point is that the only people who can give things called that are defined as counter notice are people within 79.6.
And it's the negative counter notice that opens the door to the FTT. Otherwise, you don't go anywhere near the FTT for the reasons we looked at earlier on, because they'll be deemed admissions.
So if this point had been in everybody's mind at the outset, the correct response, you say, of the right to manage company would be to say, Assethold Limited, although we served you a claim notice, it now turns out you're not a landlord, therefore we're going to ignore your counter notice. So we haven't received any qualifying counter notices, so our RTM has just kicked in.
So you had a number of ways of doing it if you were the RTM company. If we were going back in time and starting again, I would say to the RTM company they have the following options. The first is just decide that my client is not a landlord. Don't even serve them with a claim notice. Proceed. That's what happened in A1 Properties. They decided certain people were not landlords. That's why they didn't serve them. And then what you'd have to do, you'd have to hope Millcastle served a counter notice, and then you join the RTM, join my client to those proceedings. That'd be one way of doing it. The other end of the spectrum might be to serve an equivocal counter notice. My positive case is you are not a landlord, but I recognise I could be wrong. So I serve this notice upon you. If you want to put a counter notice in, I will apply to the FTT. We will have the tribunal determine that question, because it must have jurisdiction to determine whether it has jurisdiction. The third option might be the one you put to me, sort of sitting between the two houses, to serve it and then say, actually, on second thoughts, I'm now feeling a bit more bold. I'm going to decide I didn't need to serve it and proceed. So those are the three things they could have done. If we had a time machine and we had A1 Properties, I would be going, and I was advising the RTM company in 2021, I would have said to them, those are your three options. What do you want to do?
Or the fourth option, you say, which is what they did, is not take the point, treat you as landlord, but then they're stuck with the costs.
Quite, yes. Because they clearly had the opportunity to take this point. Because we explain it in paragraph 2 of our pleading. We couldn't make it any clearer. We're not registered, but nonetheless we purchased it. We say that's enough. Now, as we'll come on to on the respondent's notice, I actually say they were right to do what they did because we are a landlord. But it doesn't matter for these purposes. They made the decision to serve. My lady, yes.
I mean, there's a small point that you only give that explanation when you're in the middle of proceedings, but you haven't told us that there was any earlier explanation of that point.
No, I accept that, and I'm focusing on there may or may not have been. I simply don't know. I focus on the pleadings because that's what was before us, and I focus on the pleadings because that's what ended up being particularly so important in Benedictus. The point, we'll come to this in a moment in Benedictus, once you engage the formality of the court, you're stuck with your pleadings in the way that we all know. Sorry, my lord.
I was going to say, but it is actually noticeable that they did serve the claim form on the claim notice on Millcastle, which suggests that somebody had searched the register, or at least thought there might be a question as to whether Millcastle was still the freeholder. Because otherwise, why would they serve Millcastle?
Well, I don't know, and I don't want to speculate. I don't want to speculate into it. I hold no brief from Millcastle on what arguments they may have taken. Our position is that very, very narrow one. served us. You issued against us asking a determination that would bind us. You
On the
pleaded
basis that you were the landlord.
Quite.
That's your point.
Quite, yes, yes.
They didn't just serve you to say, we don't think you're the landlord,
No.
but we're serving you just so you can make whatever arguments you want.
Yes.
They served you on the basis you were the landlord.
Yes. And then made positive aversions in their pleadings. That's why I think that's why it's so much narrower than my learned friend suggests. So just coming back to Benedictus, that's why I say we're in the first part of what Lord Justice Stocker was discussing at 183 to 184. Their actions triggered our counter notice, and that's what confers the FTT's jurisdiction. That's your essential fact. Lord Justice Stocker then moves on to ask himself, well how would this estoppel play out in the present case? And it's his paragraph starting "for my part" all the way down to "formulation by the learned judge."
Do you want us to read that to ourselves?
I think that makes much more sense rather than me trying
I
to
think
read
so.
the whole thing out. If I just interpose for a minute, my junior just reminded me of something I've said, which she tells me I mustn't have said. I appear to have suggested that the bundle, the TR1 in the bundle, appears to be incomplete. I am reminded, as the FTT explained in paragraph 12A of its decision, that that's because it was only a file copy, and there was in fact another version that was out there. So please don't take me as accepting that our TR1 was defective. The version that we gave to the FTT was not the final version. If I can just put that to one side. Right. So look at then this paragraph of Lord Justice Stocker's judgment. What I take from that lengthy paragraph is that in principle, there's no reason why you couldn't have a relevant estoppel arising from the pleadings. He simply says that it might have been right to allow the tenants to adduce evidence that the landlord knew that the tenants were not in occupation but agreed for some ulterior purpose. So he's essentially saying that there might be some kind of sham or bad faith argument that could be run to defeat an estoppel. Well, that may or may not be right. It's certainly not our case. No one's alleging anything like that. That either they took the point or we took the point. We knew we weren't the landlord, but we nonetheless, for some ulterior motive, took that point. The point I want to take from that paragraph of Lord Justice Stocker's is that he was clearly, in my submission, comfortable with the idea that you could have the relevant estoppel just on the pleadings. And we say that's what you've got here. You've seen the pleading position. We'll come to reliance in a moment. The reason he didn't need to decide it on that is that there appears to have been some particularly unusual factual matter which may have merited exploring, but no one's suggesting there's anything here. And then the third element of Lord Justice Stocker's decision is the paragraph starting the position here. And all the way down to the So- So I break his judgment into three parts. I've got the bit on 183 over to 184 is part one. Part two is the for my part down to by the learned judge. And then his part three is at the position here.
I don't think it's technically a new paragraph because it's not indented, but it's a news.
Oh, sorry, yes, you're quite right. The point he's making in that last part is the broader point of principle. You can't, on the one hand, aver you're in occupation, and on the other hand, deny you're in occupation. It's the very last sentence. They were, as the judge said, approbating and reprobating, and the assistance of the court should not be available in support of such a course of action. That's the point of principle. Whether you want to call this estoppel, abuse of process, or something else doesn't really matter. You can't, as a matter of fundamental fairness, you can't on the one hand positively plead X and then deny X later on.
Well, it might matter whether you call it estoppel or something else, because it might be an essential requirement for estoppel that there be some detrimental reliance, and it might not be necessary for another formulation.
Well, let me, at least in the landlord and tenant context, in this particular context, it won't matter. And I'll take you to reliance in a moment, because there's a very helpful case explaining what counts as detrimental reliance in this particular context. So those are Lord Justice Stocker's 3 points on this. And Lord Bingham, just Lord Justice Bingham, sorry as he was then, I would suggest makes the same 3 points.
I'm not sure I've noted what the 3 points.
So, the first point I take is 183 to 184.
It's not a jurisdiction.
It's not jurisdictional. It's preventing you from denying an essential fact which you had to establish. And the essential fact they have to establish here is that we are a landlord, because that's our gateway to giving our counter notice, and it's the counter notice that gives the tribunal jurisdiction. His second point is the paragraph starting "for my part" down to "by the learned judge." And I say what you take from that is he accepts that in principle, pleadings can give rise to an estoppel.
Yeah.
He identifies on the facts of this case one particularly unusual factual matter which maybe should have been explored, but no one suggests that's present here. And then his third point is the point of general principle from the passage starting the position here. And that's his point, that you can't plead X and then deny X. And Lord Justice Bingham, I say, makes the same 3 points. This is page 186. The paragraph starting, "the question is therefore," down to "decision defined in the Act." That's agreeing in my submission with Lord Justice Stocker's first point. It's not about jurisdiction. It's about the fact that you can't deny something that's an essential element of your claim. The second part of Lord Justice Bingham's judgment agrees with the second part of Lord Justice Stocker's, and it's the paragraph starting "the second question." Now, the very slight difference, although I'll pick up on in a minute, is that he does say 5 lines down, "since any estoppel involves proof of reliance," so my Lord's point that I'll come back to in a moment. But what he's accepting in my submission, starting the second question, ending simply on the documents before him, he's not denying that in principle you can get your estoppel from the pleadings. It's always a question of fact.
Describing it as estoppel by convention.
Yes.
Does the stopper do the same? Yes.
Yes.
It did.
Yes.
So we're not talking about abuse of process in that sort of broader word sense. We're talking about a form of estoppel by convention.
Correct, yes. Yes, this isn't a Johnson and Gore Wood kind of case. It's a very, very narrow and fact-sensitive one, where you only know if it's met by looking at the pleadings. And then his final point, it seems to me, is Lord Justice Stocker's third point as well, at the end of 187, paragraph starting "in support of the judge's approach." And if I could just ask the court to read that all the way down to 188, "I accordingly agree the judge was right to strike out John's answer." That's his point of principle. He couldn't make it any clearer because he discusses it as being founded on public policy or justice, and he tests it by reference to Party A and Party B, not the facts of this case. So I say, subject to a reliance point that I'll deal with in a moment, I say that's the answer. And Judge Cooke is right for the reasons she gives. So if we can go in the main bundle, tab 7, I can go through her judgment, and I can hopefully quite briefly explain why I say she's right. So it's paragraph 21, page 89, where she goes through, in slightly different order from her friend, but she goes through all of the points that he put to you this morning. The first is she said, well, she's not subverting the statute. You see from 21. She agrees that only specific persons can have their costs, but that doesn't prevent the FTT from awarding their costs where someone doesn't deny a condition is met or an estoppel arises. It's not this. It's the Benedictus point. It's not jurisdiction. It's you can't deny the essential fact. Secondly, she says, well, there's no inconsistency here. I think that there's two answers to what my learned friend said. The first is, as I read her judgment, I think she is talking about an estoppel for the purposes of section 88 only, because that's plainly all that was before her. She wasn't asking herself questions about could landlords exercise rights of entry, even if they weren't really landlords. And when she says in 26 that it all depends on hypothetical circumstances, in my submission she had in mind the kind of scenarios that my lord put to my own friend this morning. You say to someone, you've got to give me the service charges. The answer isn't, well, I am or I am not a landlord. The answer is, I haven't got any of your money. If I haven't got any of the money, there's nothing to give you. You don't help yourself by turning this into an academic debate about the nature of estoppel and potential consequences in fact patterns that haven't arisen. She's perfectly entitled to reject that argument in the way that she did. She then, under estoppel can't be used to outflank a statute. She looks at the cases my learned friend relies upon, in particular the action strength case at paragraph 29, and she just concludes at paragraph 32 through to 34 that this isn't one of those cases. It's not jurisdiction. It's benedictus. Not conferring a jurisdiction that doesn't exist. I won't trouble you with her point 4 plintal, because my learned friend didn't trouble you with this, and for what it's worth, I agree with him. I'm not sure what you get from looking at, frankly, a quite sparsely reasoned Upper Tribunal decision on its own facts. If plintal was right or wrong, that doesn't really tell you what the answer to this appeal is. And then finally, estoppel is a shield, not a sword. In fairness to my learned friend, he didn't really take that point, so I'll trouble you with it. I'll deal then with 6, the no recognised form of estoppel. And this is the point about reliance. Judge Cooke's answer to that is the last sentence of paragraph 49. As to detrimental reliance, the act of engaging with proceedings and incurring the cost are clearly detriments. Now, she doesn't cite any authority for that, but that's completely consistent with the approach that's generally taken in landlord and tenant law. So if we go in the authorities bundle to tab 21, the Free Grammar School of John Lyon and Mayhew, the facts of this involve a particularly difficult interaction between leasehold reform legislation and landlord and tenant 54 Act legislation. But for our purposes, we can take the essential material incredibly shortly from the headnote. Page 275, the very last line, the third thing the judge found. The judge found the tenant knew the landlord had served the wrong form of notice. But by serving the counter notice under 54 Act, was stopped from denying the validity of that notice. The tenant appealed to the Court of Appeal and held 3. The tenant was indeed stopped blah, 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 blah. The landlord has suffered detriment in relying on the counter notice. Let's look at how they describe that detriment. It's page 279. In the middle of the page, Mr. Driscoll did faintly argue that the landlord called no relevant evidence they were affected by what Mr. Mayhew did. But in my judgment, it's indisputable that the landlord relied upon the Section 25 notice. They relied on nothing else. They don't have to go further and show what they would have relied upon had there been no representation that its validity was not disputed. By incurring lawyers' and surveyors' fees, the landlord suffered obvious detriment. That's our case. You serve a statutory notice upon us. The statutory notice requires us to do something, even if only consider it and think about whether the claim is a good one. In fact, we did more than that, as you know. We served a counter notice. We put in pleadings. We instructed counsel to attend the hearing that was due to take place, and then the claim was abandoned the day before. I don't disagree that reliance and detriment are things we have to show and have regard to, however you want to put it. The point is that there's no closed category of what amounts to reliance, detriment in any given case. And as this one shows, serving a notice and putting your landlord to expense is detriment. You don't have to do any more. So for all of those reasons, we respectfully say Judge Cooke is right. And as you'll see from how we put our case, we do say the answer to this is much narrower than my learned friend opened the case. Now, there's some other bits we both touch on in our skeletons, but I'll flag now to explain why I'm not going to deal with them unless you want me to. The first is there's another Upper Tribunal case called Robert Court that Judge Cooke was worried might be a bit inconsistent with what she decided in this case. But as my own friend's not relying upon it, I'm not sure I need to say very much about it. I simply say that the Robert Court case, as we explained in our skeleton, it was a completely open to discussion. And more importantly, it's all about Section 89 costs, not Section 88 costs. The more important point on it as well, I'll just give you the reference for it. It's paragraph 64 in that report if you want to go and look at it. There was never agreement about whether a notice was valid or whether someone was a landlord. It's not like our case. There's never been that commonality that you found in Benedictus. But I'm not sure it takes us very far because I say Benedictus is the answer, and that's the end of it. And I'm not sure that looking at Upper Tribunal cases on their own facts take you very much further. I'm happy to if you'd like me to, but otherwise I can stop there on the appeal. And with any luck, subject to your views, I can probably complete the respondent's notice today.
No, I think we're content with that. Thank you. So moving on to the
respondent's. Moving on to the respondent's notice then. So, the premise of the respondent's notice is not merely that they are stopped from denying the landlord, it's that we are the landlord within the meaning of Section 79(6) and therefore within the meaning of Section 88. Put simply, I have two ways, we say, of showing that our equitable title, which is what we plainly had, is enough to make us a landlord under a lease, which is the requirement in Section 79(6). I'll make that good in a moment, but I've got two initial points I've got to deal with. The first is, in my learned friend skeleton, and this is touched on in oral argument this morning, he says, well, there hasn't been any finding that we have an equitable interest and we didn't need any evidence on that. That's why I took you to the FTT costs decision when I did. Paragraph 2 noted that we purchased it, but it wasn't registered. Paragraph 12, we pleaded our purchase. Paragraph 14, the tribunal accepted we had indeed purchased it, as we contended.
Did they have evidence on which they could legitimately make that finding?
Let's just see exactly what they had.
Taking us to the pleadings, that might be the answer. Are they in the supplemental?
I'm just seeing if there's a... Yeah, let's just have a quick look at supplement.
The submissions might help us.
Yes, so our statement of case, page 173 of the supplemental bundle. So our paragraph 2, we exhibited the freehold title, the plan and the TR1.
Okay, there's a statement of truth on this. It
Yes.
doesn't say in terms, or does it, that we are the
No, it doesn't. It doesn't in terms say that. Paragraph 2, we purchased it, registration is pending, and we give detail of that. I mean, the fact that we are the equitable owner, we say, follows as a matter of law.
anything could have happened in the meantime.
Well, can I just answer that very briefly? Because it wouldn't have mattered if anything happened in the meantime. You've judged the claim on the relevant date, which is the date of the claim notice.
Yes, but sorry, in the meantime, I should have been clearer, between October 2019 and the date of the claim notice.
Oh, I see your point. Sorry, no, that's a rather different point to the one that I broadly answered.
So there isn't.
Do we know if your clients have now become a freeholder?
We do. My learned friend kindly accepts that.
There's something in the supplemental bundle which I'm not familiar with, which is an unofficial copy of the register.
So, if I I'm finding something else first. If we just go in the main bundle to page 36, I was going to take this from my learned friend's skeleton.
Right.
Because
So what document are you in?
So I'm in page 36 of the main appeal bundle, tab 3, and this is my learned friend's skeleton for this appeal. I was going to take it from here because he'd kindly done the work. Paragraph 10. Although the freehold transfer was eventually registered in March 2023, the land registry records indicate that pursuant to a transfer application made on April 2022 in respect of a transaction said to have taken place on the 10th of October 2019. So the transaction date marries up with what the FTT had. Now that's not the answer to my lady's point, which is what did the FTT judge have? They would have had all that in 2021.
I mean, you need, don't you, for your response notice, you really need a finding of fact that Assethold was the equitable owner at the date of the claim notice.
Before I answer that, can I just turn my back for a minute? Because I think this is... I'm going to ask Miss Gibson to deal with this because I think she has the material to hand much more easily than me. So thank you.
Certainly. Yes, Miss Gibson. Thank you.
Thank you, my lady. I think taking the second point first, my lady's question. I believe it was, do we not need an express finding that we are the equitable owner? On that, I say no. I say that for two reasons. First, the FTT finds the sale and purchase completed on the 10th of October 2019. As a matter of law, being my second point, looking through then the Land Registration Act, I'll just look up in the bundle. Section 27(2), tab 4, the authorities. Page 70 of the authorities bundle. Really, it's section 27(1). If a disposition of a registered estate or registered charge is required to be completed by registration, it does not operate at law until the relevant registration requirements are met. Now, the transfer of the freehold from our predecessor to Assethold was required to be registered, and that point is not in dispute. And so the effect we say of section 27(1) is that as that requirement has been met, it had not been met at the time of the claim notice. When we are in that gap, the effect of section 27(1) is that we are the equitable owner. And it's accepted in the case law that this is indeed the effect of section 27(1). Now, a point of difference between ourselves and my learned friend is that he presents, in my respectful submission, that there is only one way to be an equitable landlord, being under an agreement for a lease which can be enforced in equity by a remedy of specific performance. Whereas we say that's not quite the case. That is indeed one way to be an equitable landlord, but there's also another, being this section itself. And I think Mr. Bates may come to it later, but this was an issue in Cresta Court for Judge Cooke herself as well. And just to summarise that now, we needn't turn it up, but she accepts in her paragraph 55 that there are two ways indeed within this 2002 Act to be an equitable tenant on those facts. But we say that applies equally, at least in that narrow respect, to landlord.
Yeah, I think I understand that. I suppose my point is that it doesn't automatically follow, does it, that the transferee under a TR1 is the equitable owner. I mean, an obvious example is one bare trustee, or someone transferring title to a bare trustee. That would be one. Another might be, yes, they are initially the equitable owner, but at some point before the transfer is registered, they sell on. There are lots of possibilities. My point is that 27(1) doesn't deem the transferee to be the equitable owner. That point is left to the law, isn't it?
I think I might have to disagree there. At least the way that I interpret Judge Cooke, and maybe we should perhaps turn up Cresta Court.
Yes, and your leader may be coming to that.
He may be coming to that. He wants me to take it, or if he'll take it himself, I don't know.
Mr. Bates, are you leaving it in the capable hands of Miss
I'll
Gibson,
leave it
or are
in
you?
the capable hands. She did this bit of Cresta Court, and it was the only bit we won on. So I think I'll
Very wise, if I may say so. Cresta Court.
Cresta Court is in the supplementary bundle at the first tab.
Thank you.
So this case is, we think, relevant to the decision, which is why it was eventually put before the court, but we don't think it is binding. Obviously it's not, because it was, again, a tribunal, but it's also on a related but different point. In terms of the facts, in this case, the question was whether the tenant in the registration gap was a qualifying tenant who should have been served with notice inviting participation, as is required by the 2002 Act. And it was not lost, well, the irony of which was not lost on Judge Cooke, that we were the landlord and arguing that this tenant in the registration gap should indeed have been served with the notice, because there might be the argument that if she hadn't been served, the whole claim is invalid. So we were arguing for a broader category of tenants than our opposing counsel in that case. And in terms of the facts, this was the first grant of a lease out of a registered estate. So it was not the transfer as in our case. It was the first grant. So that there was no separate legal title holder and equitable title holder. There was only the one person who was the as yet unregistered leaseholder. And the question was whether she should have been served with a notice. And we put that she should indeed have been. And the argument on this, from our perspective, began in paragraph 31 on page 10 of this case. Judge Cooke summarises mine and Mr. Bates's arguments. Paragraph 31 starts to address the importance of the status of being a qualifying tenant, the rights that it brings, the rights that someone has to participate in the claim, the right to know, the right to be a member of the RTM, to receive a copy of the claim notice. Again, not the notice itself, not to be given it, but a copy thereof. And so it would be inconsistent, we put, with the policy of the Act to narrow down the persons who should be entitled to receive that notice based upon something as unfortunate as the land registration's delays. Example that we put was, imagine there's a brand new block of flats flung up somewhere and the land registry takes ages to register it. Is it really the case that these people that live in these flats can't exercise the RTM because the land registry hasn't ticked the right boxes to register their title? That cannot be what the policy is. That can't be how we should interpret the Act. And this turned on the definition of a long lease in section 75 of that Act. So if this turns the registration gap of a long lease that was equitable, and I would address why it was equitable next, if that equitable long lease is a long lease per section 75, then she should have received that notice. And then in paragraph 33, Judge Cooke recites my submissions, which again we reference in this case, section 1122. Now we can turn that up as well. So back in tab 1 of the authorities bundle. Page 55. This is where section 112 begins. It's the definition section which applies to per subsection 1 in this chapter, being the right to manage chapter of the Act. It goes through in alphabetical order, turning over leaf to subsection 2. In this chapter, lease and tenancy have the same meaning, and both expressions include where the context permits. Now, that's an important phrase in that sub-brackets, we can just remember that. Permits a sublease or subtenancy, and B, an agreement for a lease or tenancy. And per 3, the expressions landlord and tenant should be construed accordingly. And so I say that that means that an equitable landlord is a landlord of a lease, which is an agreement for a lease. That's how the way the 2 and the 3 interact. So the landlord under an agreement for a lease is also a landlord under a lease by virtue of at least section 1122. So that was the definitions provision which we used to hook to our policy argument about why this tenant should be a qualifying tenant per the Act. And I took the point that it's trite law from Walsh and Lonsdale that an agreement for a lease is an equitable lease. The statute expressly says that an agreement for a lease is a lease within the Act. And so why is it any different that an equitable tenant in that registration gap is not a tenant of a long lease within Section 75. And as my learned friend in this case does, our opposing counsel in that case took the point that unless we could have shown that that first lease granted was an agreement for a lease, which was Walsh and Lonsdale compliant, which would have had an order for specific performance, unless we could have shown that, then it wasn't an equitable lease and it wasn't therefore within the Act, which does make clear that at least one type of equitable lease is within the Act. And that submission of his is recounted at paragraph 42 of the judgment on page 12 of the supplementary authorities bundle.
Did you say 42?
Yes, my lady. Paragraph 42 on page 12 of Trustee Court. And then as per 43, Mr. Jacob in that case also emphasised where the context permits and made various points, such as those noted at 44, that it would be unworkable were every tenant who were equitable to be a qualifying tenant, because how on earth would they know who to serve in their block? Because everyone in reality goes to the title to look to see who is the legal owner. And then Parliament, while it might not have intended to obscure from those 10 people in that brand new block of flats the RTM, it equally couldn't have intended that everyone, all the claims fail by virtue of there being one equitable tenant that hasn't been served. And then on page 14 at paragraph 54, Judge Cooke gives her answer to the dispute between myself and Mr. Jacob, being whether Section 75, the long lease in there, it's only a long lease if it is a Walsh and Lonsdale type agreement for a lease, or whether it's also an equitable lease by virtue of being the registration gap, which Judge Cooke accepts in paragraph 55, are both equitable leases. An agreement for a lease is an equitable lease, but not all equitable leases are agreements for leases. And she puts in 55 that it would be inconsistent or arguably sterile, but for the most specialist property lawyers, for Section 75 to distinguish between a Walsh and Lonsdale equitable lease and also a registration gap type equitable lease. And so finds that for Section 75 purposes, it can include both. It can include the tenant in the registration gap. And what she eventually decides at paragraph 59 on page 15 is that if there is both a legal and an equitable lease, which again was not the facts on the case before her, there was only one tenant there, being the equitable tenant. There was no legal tenant whatsoever. So this is strictly speaking, it's over to her. But it goes to show how she analysed the problem and what she thought was important to her decision.
It's quite interesting though at 59. I know there's a rule that's in the Act that says there can only be one tenant.
Exactly, yes, I can turn to that if that would assist.
She is deciding that if you've got a legal lease and an equitable lease, you can't look at both. In other words, she's confining her situation to where the only lease that exists is equitable. Is that right? I thought that was what she was saying.
I think that is correct if I'm right in interpreting, but the reason she gets to there is both because of the requirement that there can only be one qualifying tenant of that flat, and also because of the language of where the context permits. And this is made express in her 56. So I regard a long lease in Section 75(2) as capable of including both legal and equitable leases, However, section 1122 is qualified by the words where the context permits. And clearly the context does not permit there to be both. So that is how she frames the first part, which leads her to the conclusion that when there's both, it's illegal. And then later on, after 59, she addresses the alleged unworkability of there being, where the context permits it being the equitable tenant rather than the legal. And so I would submit that the decision that on those facts was that there was only one tenant here, can only be one tenant. It had to be Miss O'Connor in these circumstances. But she said that when there's a legal and an equitable, the context permits in the case of a qualifying tenant, due to the unworkability of knowing who all the QTs are, but also because where the context permits. That was the hook upon which led her to the argument that, again, the obiter position, if there were two, it would be the legal. And I think Mr. Bates might come to the more general position that we take in the RN grounds. But in a nutshell, it's that at least one strand of it is that in this case, were we to look to section 1122, the language for Walsh and Lonsdale, an agreement for a lease is a lease. We're in the registration gap, applying Judge Cooke's law there, which is I don't think it is disputed that someone in the registration gap is or can be an equitable owner. We say we were in the registration gap. And looking to section 1122, were we to apply that to section 88 and section 79(6), the context permits that we, a landlord under a lease with management responsibilities, who cleans the block, who cuts the grass, that fixes the leaky roof, the context permits us as a landlord. If you have to go into Walsh and Lonsdale and all of that under the law, you can. We're an equitable landlord. But the context permits here that we who risk losing our rights, be they contractual, be they functions, whatever they are, we risk losing them. And the context permits the interpretation in section 88 of landlord to include us. We have these rights to clean the building. We have an obligation to clean the building in this gap. We're doing that. We served the service charge demand in that gap because we were cleaning it.
Right. Just on that, you're relying on the words context permits. I'm not sure they help you. I mean, you've drawn our attention to their presence in 112 sub 2, but that's specific to subleases or subtenancies and agreements for lease. It doesn't, whereas you're trying to use a, there's no definition, put it this way, there's no definition of landlord anywhere. So I'm not sure I can see where the words, where the context permits actually help.
If we then look to section 88 itself,
Yes.
page 26, 88(1)(a). Now, section 112 is the general definition provision that applies to the entire part of the Act, being this RTM chapter. So in this chapter, section 1122 says lease, where the context permits, can mean an agreement for a lease. So section 1122 says lease, where the context permits, can mean an equitable lease, as found by Judge Cooke.
I suppose I'm making the more basic point. It's talking about an agreement for lease, not an agreement for sale.
But the definition shows that the Act accepts that a lease or rights under a lease can include equitable rights, which, or where the context permits, can include equitable rights. And we say here the context, the reality, is that this is just correct. We are the ones doing the work. We are the ones doing the cleaning. We are the ones that need to investigate this claim notice to see if it's valid, to see just how precarious our rights are. And so the landlord under a lease can mean a landlord under an agreement for a lease, an equitable lease, an equitable landlord, a landlord in the registration gap. which is
I
Assethold.
don't think you can. I don't think you can assimilate landlord under an equitable lease with an equitable landlord under a lease. The leases here are registered, and there's no question of them being merely equitable leases. They're legal leases. What you've done is by the reversion, in circumstances where, as you say, you're in the registration gap, so you haven't actually got a legal title to the freehold. That's a different question from whether it's an equitable lease, isn't it?
Yes, but my point is that Section 1122 can shed light on how to interpret Section 88.
Yes.
You're saying by analogy, if it follows that a lease can be equitable through 1 and 2, then the same must apply
Yes.
when you also have a registration gap under Section 88.
Yes.
At least that's what I thought you were saying.
And I think you also say that what Judge Cooke said in Crester Court is authority for the proposition that there are two types of equitable lease. There's a Walsh and Lonsdale type equitable lease, and there's a registration gap equitable lease. And in the same way, when you're talking about whether you are a landlord, you're an equitable landlord because you're in the registration. Is that right? Have I understood that correctly?
Yes, so I would not like to restrict there to be only two kinds possible of equitable lease. I'm saying those are two examples. And as Judge Cooke put it, an equitable lease might be an agreement for a lease, but not all equitable leases are agreements for a lease. Kind of the Walsh and Lonsdale might be one example of an equitable lease. Another example might be a registration gap point, but I'm not saying they're the only two possible means of being an equitable landlord or an equitable lessor, equitable tenant.
Yes. I think I'm still not quite clear as to why you get an equitable interest under Section 27(1) in the registration gap if you wouldn't otherwise have one. Let's take a case where a lease, instead of being sold by A to B, is the subject of a gift from A to B. Now, as a matter of ordinary law, B couldn't get specific performance because you can't get specific performance of an uncompleted gift. But B lodges the deed of gift at the land registry and is waiting to be registered. Does B have the equitable title to the lease in that gap? And if so, where does he get it from? It's not obvious to me that he gets it from Section 27(1, which simply says he doesn't get the legal lease until registration.
I would say that B does have an equitable interest in that case because there's various ways of conceiving of how Section 27(1 does what it does, being that it results in there being an equitable owner. And that is addressed, I think, is in McGarry in the bundle.
Maybe that gifts have a particular rule because the donor has done all they need to do.
Yes.
That may be the answer.
It may be
to that
the answer.
example.
Anyway, this is all quite interesting, but as I understand it, sorry, it's very interesting, but as I understand it, in your case, your primary case is you bought the property, and there's nothing to displace the normal rule that if you buy property and you complete your purchase, you become the equitable owner. Is that right?
Yes.
And that would be the case even if you never lodged it for registration.
Yes, I think so. But our point is also more, this is essentially a question about how to construe Section 88 and looking to the costs provisions in that. We're not simply trying to look to the law of equity and go through all of that and go through Walsh and Lonsdale and say, because of Walsh and Lonsdale, we are an owner. We should be associated with the legal owner. We are in their shoes. We therefore fall within Section 88. We're saying, look at the Act as a whole. Look at the purpose. Look at the rights we stand to lose and taking all that into account, as well as the trite proposition that an equitable lease is a Walsh and Lonsdale, and also looking to Judge Cooke and Crester Court. The Act can include equitable interest. We're saying taking all that together, the way you should construe Section 88 is to construe that Assethold is a landlord under a lease, such as give it the entitlement to costs.
And answering Lady Justice Falk's question, which started this consideration about evidence that what happened continued to be the case, you would rely on the FTT's finding at paragraph 2 plus the evidence of the service charge being collected and paid
Yes.
to
Yes.
your lay clients.
We weren't cleaning the building out of the goodness of our heart. It was because we had an obligation to do that, and we were being paid to do that. And
Sorry, I think the second time you said you had an obligation to do it. Where does the obligation come from?
it came from as our purchase of the freehold and the head leasehold.
So
So
it's
it's
sorry.
obligation owed to the vendor, not obligation owed to tenants, because you're not party. Sorry, this is getting technical, but as I understand it, the doctrine of Walsh and Lonsdale doesn't make you parties to the lease in such a way that the tenant can sue you in contract. You don't have a contractual relationship with the tenant, and you haven't got privy to your estate because your estate you haven't got legal estate yet. So you may well owe a duty to your vendor to comply with the obligations in the lease, but do you owe duties to the tenants to comply with the obligations in the lease?
I think this starts in the position that we are relying upon there being a Walsh and Lonsdale
Yes.
type scenario, which we're not. It's the more general proposition that the Act is apt to include equitable landlords, equitable tenants, equitable interests. And so taking that point, it can explain one way of interpreting the Act to get to our point. And one point, such as this one, was taken again by Judge Cooke in a different case, also earlier this year, being the RM residential decision. In the bundle, the main authorities bundle at tab 31. And the facts can be taken from the head note in that on page 447.
Tab 31, did you say?
Tab 31, yes, my lady. So the actual statute and provisions in issue here were to do with whether or not the landlord could have permission to dispense with the requirement to consult before undertaking various work, so they could get the full money back in the service charge. In brief, that's not the relevant statute here. But what is relevant are, again, the propositions of law put by Judge Cooke in explaining the role of the equitable landlord in this case to its tenants in that block. So as addressed at H4 on page 447, in 2020, in December, the landlord purchased the block. It did not become the registered proprietor until January 2 years later. Then in early 2021, shortly after it bought the property, various problems were found with the building. So this is during the time when the unregistered landlord, post the purchase but pre-registration, blocks found to have some issues. And by the 2003 regulations, a landlord is required to consult before carrying out works, for which tenants have to pay a service charge. And if you don't properly consult, the recoverability of those service charges is restricted. However, an application can be made to dispense retrospectively with the requirement to consult. I think in this case, the landlord was advised by its experts that the building was so bad it had to just go ahead.
But I think where you're taking us to in this case is how the registration gap's was treated.
It's how the registration gap is treated,
I think
indeed, and
paragraph
particularly the
38.
obligations of Yes, of the obligations of that landlord in the gap. And looking at the reality of the situation. So the material part begins on page 455. When in paragraph 35 and onwards, Judge Cooke addresses the FTT decision below, which referenced section 27.1 as I took the court to earlier. And the FTT notes, well, it's quoted paragraph 17 in paragraph 35 of the Upper Tribunal. The FTT was not impressed by the applicant's arguments that as equitable owners of the property, it was entitled to do the works without consent of the registered proprietor. So basically saying, you've just bought it, you're not the legal owner, why do you think you're allowed to go and fix this roof? And at paragraph 36, Judge Cooke states, or it further explains the FTT's decision. And then at 37, Judge Cooke states, this demonstrates a misunderstanding of the law by the FTT. And paragraph 38 explains the gap. There's almost invariably a gap, registration gap between the completion of the purchase of land, which, as per the FTT in our case, found was on the 10th of October 2019. There's a gap between the completion by the execution and delivery of a transfer and its registration. The length of the gap will vary, but there will always be a gap, and until the purchaser's title is registered, the FTT said it does not pass the purchaser. Then paragraph 39, Judge Cooke explains that during this gap, the vendor holds the legal title on trust for the purchaser. As a bare trustee, the vendor has no power to make decisions about the property and must act at the direction of the purchaser. Then Judge Cooke cites section 24 of the Act, which is not directly an issue in our case. And again, we don't express rely upon it. We say it's more an example of when an equitable owner has certain powers to do things.
Cute.
And then paragraph 41 is, I think, the most crucial paragraph in this decision. And 42, that is. The practical effect of that being the delay between the completion and the registration. The practical effect is well known to anyone that's bought a house, the lucky few, and conveyancers. On completion day, the transfer is signed and dated. The keys are handed over and the purchaser moves. The property belongs in equity to the purchaser. And to say that at that stage it is not the owner of the property both flies in the face of everyday reality and betrays a failure to understand equitable ownership. So applying that to our facts, after the completion, this block began in equity to Assethold. And to say at that point that Assethold was not the owner flies in the face of everyday reality and does not properly understand the nature of equitable ownership. True, there's a few things that the owner can't do. It can't give an NTQ. We don't dispute that. But entering the property is not one of them. And then paragraph 42. About halfway down that paragraph, the sentence beginning equally it took on at completion all the landlord's obligations to maintain the property and took the benefit of the tenant's covenants to pay the service charge. And then 43 overleaf. So the appellant's right to take possession of the property and carry out the work cannot be in doubt. And so that's a rather long-winded way of getting back to my Lord's question, that in this gap, we're effectively stepping into the shoes of.
And 42 says you do become liable on the obligations. And Judge Cooke refers to the Landlord and Tenant Covenants Act, which I've just looked at, and it says that where the assignment is by the landlord under the tenancy, then as from the assignment, the assignee becomes bound by the covenants. So I suppose that raises the question whether the assignment is when you sign the TR1 or when it's registered. But I can see that it may well be from when you execute the TR1. That's the date of the assignment. So you do become bound under the Landlord and Tenant Covenants Act from that date, even though you're not yet registered.
Yes, ma'am.
What I've not quite understood is when in paragraph 39 she says, joint the gap, the vendor holds the legal title on the bare trust for the purchaser, whether that is something that's derived from section 27 or whether it's derived from the general law that if you buy property and it's completed in the sense that you've paid the money, they've executed the TR1 but you haven't got the legal title, it's that which makes you the bare trustee. But I don't think it particularly matters, because in your case you did your case is that you did buy the property on the 10th of October 2019, and from then you were the equitable owner.
Yes, my lord. If it interests you, it's quite a lively debate in this type of the world of how this equitable ownership is conceived of, whether it is a bare trusteeship or whether it's something else, like maybe an estate contract or the like. And we needn't turn it up, but if you want to read more about it, it's in McGarry and Wade in the authorities bundle at page 599. In paragraph 653, particularly footnote 352, there's a good article by Martin Dixon there that analyses it.
Look at that overnight.
Doesn't matter. But thank you.
Does that complete your section, Ms Gibson, or are you carrying?
Unless and until Mr Bates wants me back up again, I think it does. Thank you.
Thank you very much, Ms Gibson. Now, Mr Bates, where are we?
I'll be very brief because that's largely covered everything we need to cover.
I suspected it might. So
I am both grateful and impressed. So thank you to my learned friend for dealing with that. That largely then, frankly, covers all I need to say on the respondent's notice point. The first on our respondent's notice grounds is you can interpret section 88(1) as including landlords under equitable leases. My learned friend's taking you through all that. It's a construction point driven as much by policy, which is why I took you to A1 at the beginning. That's why my learned friend focused so heavily on the where the context permits point. We're conscious that we're not trying to create general changes to the law of property here. We're trying to see how this statute could work on these not uncommon factual scenarios. And under the analysis we give, not only effectively, my learned friend's clients will write to serve us with the claim notice because we are sufficiently landlord that we fall within the scope of section 79.6. And if we fall within 79.6, then we get our 88 rights. That's our respondent's notice ground one. And then the point we took from Cresta Court was, if it's good enough for tenants, that equitable tenants can be included, why is it not good enough for landlords? We rely upon Judge Cook's analysis. I should say, for completeness, Ms Gibson and I are trying to get Cresta Court up to this court, but not on that issue, because that was the bit we succeeded on. But I just float that for the moment. And then the second of our respondents' notice ground 2 points is even shorter. It simply says, well, the other way of looking at this is that there's no reason why you couldn't treat both Millcastle and our client as landlords, because there's no reason why you can't have two landlords under this legislation. We're only looking at, you only have to be a landlord, not the immediate landlord of the occupational tenants forming the RTM company. And that's the only point we wanted to make on the two respondents' notice grounds. The real point, I suspect, is whether this court takes the same approach as Cook does, because if you're with us on Benedictus, these issues don't arise. If you're not with us on Benedictus, then the logically prior question is, do we have enough to get over my learned friend's objection about evidence and my lady's questions about findings? And if Ms Gibson couldn't persuade you, I'm not going to be able to do any better on that. So thank you very much.
Thank you very much. Very well, then we'll continue back to you in the morning for your reply, and then back to you for your reply. I wouldn't think we're going to be terribly long.
No.
Very well, thank you all very much indeed. I don't know if you were given any warning, Miss Gibson, but you dealt with it with considerable aplomb. You can take it up with your leader later if you didn't.